5 seconds to go. Start. Mr. Pathak, while not disputing that if the application filed on May 31st, 1958 was incompetent at the stage it was filed, the order passed by the civil judge would not bar the consideration on the merits of the later application to set aside the ex parte decree sought to get over this obvious situation by a submission that even if Order 9 Rule 7 was inapplicable, the court had an inherent jurisdiction saved by Section 151 CP Code to entertain the application outside the specific statutory provision, and that it must be taken that the appellant invoked that jurisdiction, and that court being thus competent to grant or refuse the relief followed the later alternative in the circumstances of the case, and that consequently the proceedings before the court were not incompetent, and that the order passed on the application dated May 31st, 1958 was therefore with jurisdiction. On this submission, which we might mention has been asked for the first time in this court, the first question that arises is whether the court has the inherent jurisdiction which learned counsel contends that it has. For the purpose of the discussion of the question in the context of the relevant provisions of the code, it is unnecessary to embark on any detailed or exhaustive examination of the circumstances and situations in which it could be predicated that a court has the inherent jurisdiction which is saved by Section 151 of the Civil Procedure Code. It is sufficient if we proceed on the accepted and admitted limitations to the existence of such a jurisdiction. It is common ground that the inherent power of the court cannot override the express provisions of the law. In other words, if there are specific provisions of the code dealing with a particular topic and they expressly or by necessary implication exhaust the scope of the powers of the court or the jurisdiction that may be exercised in relation to a matter, the inherent power of the court cannot be invoked in order to cut across the powers conferred by the code. The prohibition contained in the code need not be expressed but may be implied or be implicit from the very nature of the provisions that it makes for covering the contingencies to which it relates. We shall confine our attention to the topic on hand, namely applications by defendants to set aside ex parte orders passed against them and reopen the proceedings which had been conducted in their absence. Order 10, Rule 1 requires the parties to attend on the day fixed for their appearance to answer the claim of the defendant. Rule 2 deals with a case where the defendant is absent but the court, from its own record, is apprised of the fact that the summons has not been duly served on the defendant in order to acquaint him with the proceedings before the court. Rule 2 contains a proviso applicable to cases where, notwithstanding the absence of service of summons, the defendant appears. Rule 3 deals with a case where the plaintiff along with the defendant is absent when the suit is called on and empowers the court to dismiss the suit. Rule 5 deals with a case where the defendant is not served properly and there is default on the part of the plaintiff in having this done. Having thus exhausted the cases where the defendant is not properly served, Rule 6(1)(a) enables the court to proceed ex parte where the defendant is absent even after due service. Rule 6 contemplates two cases. The day on which the defendant fails to appear is one of which the defendant has no intimation that the suit will be taken up for final hearing, for example, where the hearing is only the first hearing of the suit and where the stage of the first hearing is passed and the hearing which is fixed is for the disposal of the suit and the defendant is not present on such a day. The effect of proceeding ex parte in the two sets of cases would obviously mean a great difference in the result. So far as the first type of cases is concerned, it has to be adjourned for final disposal, and as already seen, it would be open to the defendant to appear on that date and defend the suit. In the second type of cases, however, one of two things might happen. The evidence of the plaintiff might be taken then and there, and judgment might be pronounced. In that case, Order 9, Rule 13 would come in. The defendant can, besides filing an appeal or an application for review, have recourse to an application under Order 9, Rule 13 to set aside the ex parte decree. The entirety of the evidence of the plaintiff might not be concluded on the hearing day on which the defendant is absent, and something might remain so far as the trial of the suit is concerned, for which purpose there might be a hearing on an adjourned date. Stop.